Could you also do a clap?
This is TVW Connects.
Let's dive right into the questions.
Hi, my name is Noah.
A student-driven Q&A where Washington's youth connect with elected officials, state leaders, and political experts.
Welcome to TVW Connects. Today we're joined by Washington Supreme Court Justice Raquel Montoya-Lewis. Justice Montoya-Lewis was appointed to the state Supreme Court in 2019 by Governor Inslee. She took the oath of office on January 6, 2020, and is the first tribally enrolled member to sit on a state Supreme Court and the second Native American to sit on any state Supreme Court. Welcome to the show, Justice Montoya-Lewis. We want to recognize all the students who have participated by submitting questions. The level of civic engagement the students have demonstrated is remarkable. Students, can you welcome Justice Montoya-Lewis by giving her a big wave? All right, now that the students have had a chance to say hi, do you have anything you'd like to say before we let them take it away with their questions, Justice?
I look forward to our conversation.
Awesome. So the students have taken some time to research the role of the Supreme Court and your work as a justice, and they have brought some very thoughtful questions for you. So with that, let's get to it. Our first question is from Ansen about your unique experience as a tribal judge.
Good afternoon, Justice Montoya-Lewis. My name is Ansen Wang, and I'm an 8th grader at Open Window School in Bellevue. You served as the chief judge for many nations and tribes, such as the Lummi Nation and the Upper Skagit Indian tribe. How has your background as a tribal member influenced your decisions and views for the cases you presided over on the state Supreme Court? If so, in which way? If not, how do you manage the difference between the two roles of chief judge and Supreme Court justice? Thank you.
Thank you, Anson. That's a great question. I would say that the work I did in tribal courts, which was most of my career, about 20 years, influences the work I do now every day and has since I moved from serving tribes to working in state courts. My experience with the two of them, it really demonstrates that you can have multiple ways to define justice and to get to a just result. So the biggest difference is in tribal courts, my role as a judge was to be a part of the community, to understand the community, to understand where the people who came in front of me were, who they were in the community. On the state court side of things, there are all kinds of rules that say that the judge can only know what they hear in the courtroom. And so I had a much more, and still have a much more limited set of facts. I have much more limited access to what brought people to the court. So that is something that I continue to find sometimes very frustrating. And I think there are good things about that as well. I think we have those reasons, those rules for a reason. But that difference makes me as a justice really want to understand as much as I can about the stories of the people that come in front of us. Sometimes those people are not, individuals, they're corporations, or they're the state, or they're an agency, but I still want to understand what everyone's interests are at the crux of the case. That's always what I'm looking for.
Our next question is from Philman about the law and its relationship to equity and justice.
Hello, my name is Philman Hudri, and I'm a student at Lake Washington High School. Your commitment to advocating for equality and justice is evident throughout your legal career. When have you felt your influence on the Supreme Court contributed significantly to advancing the principles of equality and justice?
That's a very thoughtful and interesting question. And I think that you're right. Those principles drive really everything that I do. The place where I think it's been the most effective so far has been in having a wide-ranging statewide conversation about how people become lawyers. Before I went to law school, I had never met a lawyer. I didn't even really know what they did, to be quite frank. No one in my family had any experience in the law. So it was everything was brand new to me, going to law school, the way you study the law, what the law does and how it works, everything was new. So I was very lucky when I took the bar exam that I passed it the first time. The bar exam is something that you take after you finished law school, and if you don't pass it, you can't become a practicing attorney. And it's one way to be a lawyer. You have to take this test, pass it, and then you can be licensed. Over the last 3 years, I've been working with a group of lawyers, professors, students, people from all walks of life, to come up with recommendations to our Supreme Court to suggest alternative ways to be an attorney. And the basic driver for all of us who have been doing all this work is to make it more equitable for people to become a lawyer. Everyone's great at test taking, but that doesn't really reflect what we do as lawyers. So right now we have a series of recommendations that are in front of the Supreme Court for adding ways to become licensed as an attorney. We're in a period right now called notice and comment, where the proposals are out for the public to provide feedback to the Supreme Court about what they think about expanding ways to become licensed as an attorney. And I'm very hopeful that we will have some additional pathways over the next few years. It's quite a process, but I'm very proud of the work that the task force has put in. I'm very proud to have been able to convene all the people to do that. And I'm hopeful. I hope that it expands the ways people can become lawyers. And I think ultimately that benefits the public tremendously.
Perla has this next question.
I'm Perla Quiroz from River Ridge, and what case has stayed with you the most out of all the cases you have been with?
So Perla, I will just say I noticed this question earlier and I've been thinking about it all day. It's really a hard question to identify one particular case that has affected me the most. I think the best way for me to answer that is to say it's not really one case, it's an approach. So as some of you read, I have spent many years presiding over drug courts. So people that come to the court because they've been charged with a crime, but they have an underlying drug addiction that is really the basis for the crime. So they might get arrested for stealing, but the driver for that was they were trying to get money so that they could buy their drug of choice to use that. Those kinds of folks would get screened in our court. I've done this both in tribal courts and in state courts. And if it was appropriate that for them to come into a therapeutic drug court, then they would come into our drug court. And that approach to working with people is completely different from anything courts do. Most of the time in the trial courts, we're hearing trials. Sometimes they're jury trials. Sometimes there are people that plead guilty to things. In a drug court, people come into that court, they commit to go through the entire program. The fastest you can do it is a year. And it starts with the first, usually 3 months or so. They have to come into the court in front of the judge with everyone else who is in drug court and all of the professionals that are working with them, all in the courtroom. And they talk to the judge. And we go over how they're doing, if they have been going to their treatment program, if they've been able to not use drugs for that week. If they haven't been, what's been going on that has resulted in a relapse. And the whole idea behind it is how can we support you so that you can become a part of the community and not just functional, but happy. So we really are looking at the whole person. I loved doing drug court because I got to know everyone who came into the program, whether they successfully graduated the program or for some other reason they didn't. Each of those people that I got to know stays with me. Sometimes I still get to hear from them and hear how they're doing. And in fact, just a couple of days ago, someone who to be pretty honest, the beginning of her time in drug court, I really wasn't sure that she was going to be able to do it. She really had a hard time. And it was very rocky whether she was going to be able to stay in our program. And she did. And then once she was finished with drug court, she relapsed for a little bit. We were very worried about her. But she used all the skills that we had helped her to build. And I will say those are not skills we gave her, those are skills that she learned. She got clean again and has been since. So at this point, it's several years. She works in a different state now, doing training for people who are first responders who are responding to someone who has had an overdose. So she has completely turned her life around. So I just, the other day, somebody texted me a picture of her doing that work and doing some trainings. And it was just very exciting to see that. So I don't get to do drug court anymore because I'm on the Supreme Court, but that is something I missed very much.
Thank you for sharing that story, Justice. We're now going to move on to Gray with a question about building understanding between judicial jurisdictions.
Hi, my name is Gray Nichols, and I'm a senior here at Kingston High School. I learned that the U.S. Supreme Court has ruled against Native Americans 72% of the time, primarily due to the lack of knowledge about tribal law. How are you using your position to increase awareness among your colleagues about the intricacies of the tribal justice system?
I would say that's an ongoing process to help people, not just my colleagues, but the public, other attorneys, understand what happens in tribal courts. That percentage is pretty shocking. And when I very first became a lawyer, my second job out of law school was representing tribes. And one of our projects was to try to get United States Supreme Court justices to come to tribal communities, to reservations, and meet with their counterparts in tribal courts. It was a complicated process, but eventually it happened. And it's something that is an ongoing thing where there are tribal attorneys who work to get Supreme Court justices to see the justice system in a variety of different tribal communities. One of the things that I think people don't really know about tribal courts is how busy and complex those systems of justice are. And sometimes they look very much like a state court with a judge in a robe sitting at a bench above everybody else. But very often they look very different. I've worked in many tribal courts where we held hearings sitting around a conference table trying to problem solve. So the biggest thing that I try to do when I talk to my colleagues on the court, when I talk to others who are interested in what's happening in tribal courts, is to say two things. The first one is figure out who the tribes are that are near you and go give them a call and see if their court hearings are open to the public. Sometimes they are, sometimes they aren't. Go watch, get to know the tribal judges that are nearby and the tribal court systems, because you will always learn something new. The other thing is to recognize that there are multiple ways that we can define justice, that we can, as judges, involve the people who are in front of us in their own problem solving. And that is something that I think tribal courts are really good at, because in general, we have the time and also the expectation from the community that the court is a place where people can go to get support to solve problems, as opposed to a place where they go to get in trouble, which is pretty much the way people think about what happens when you go to court. If you have to go to court, well, nobody really wants to be there. So in tribal communities, we really try to build courts where people might not be happy to be there, but they can see it as a place where there's a genuine interest in supporting families and the community and moving towards success and towards justice. And maybe that looks different, but it doesn't make it wrong. So I do a lot of work with my colleagues to explain the work that I've done, to explain what I've learned and what I bring with me to the state court system. And it's a really important and active part of what I do. But based on the statistic you cited, I think you can see there's a lot of work to be done. One person can't do it all. So I am very hopeful that I can start a conversation, but I think that conversation is one that lots of people are going to have to take up, and it's years in the process of developing relationships between jurisdictions, tribal jurisdictions, state jurisdictions, federal jurisdictions, and building that respect.
Building upon our understanding of tribal courts, Jaden has a question about state and tribal governments.
Hi, my name is Jaden Alarde. I'm a senior at River Ridge High School, and my question is, what is the biggest issue with states' involvement in tribal government?
The biggest issue, I think, between state and tribal courts is when you have a situation, and this is sort of unique to Washington, where you have a situation where the state has jurisdiction over something that's happened and the tribe does as well. So by way of example, this in many places in the state of Washington, the state can prosecute a juvenile, someone under the 18, for a crime they've committed on tribal land. That can be prosecuted in the state, and it can also be prosecuted by the tribe. So you can imagine, first of all, maybe a 15-year-old, one of your friends, makes a bad decision, and they're a tribal member, happens on their reservation, and they get a notice that says you have to go to court, or in the worst case scenario, they get arrested and they spend a night in juvenile detention. So imagine the sort of anxiety and fear that might create. They might be prosecuted by the tribe, but there's also sometimes the potential that they can get prosecuted by the state. And sometimes the approach to how you work with a young person who is in trouble is completely different from what the county prosecutor thinks should happen versus what the tribal prosecutor thinks should happen. We have some rules in the state of Washington that allows tribal court judges and state court judges to preside over the same case together. It's not used as often as it should be. But that is a place where I think there is a lot of tension when people are really facing what in any other circumstance would really look like being tried for the same crime twice, which is a violation of our double jeopardy principles in the state and federal systems. So there's a lot of complexity to those issues. Like I said at the beginning, I really try to boil things down to the heart of the problem, and the heart of that problem there, if you don't have judges who are working together and talking about the person or the family that they're both working with, is that you can end up with results that are in tension with each other. So if I were in a tribal court and I said to that juvenile, I want you to enter a therapeutic juvenile drug court to address these underlying issues. And the state says to that same juvenile who is now in the state system for the same issue, we want to send you away to a rehabilitation center away from your community. That's what we're going to do. You can see how those two things can't work together. And the person who's caught in the middle is the young person. So that's an area where I think we have a lot of work to do.
Connor has another question about the different tribal courts in the U.S.
Hi, my name is Connor Cornwell and I'm a senior at Kingston High School. I've learned that you worked for 3 different tribes and each had their own legal systems and languages. Along with working for Scowal, what are the major differences you found between each different tribal court and the Supreme Court of Washington?
So there's a couple of things that I would say are immediately obvious differences. And I kind of talked a little bit about it, but I'll just kind of build on it a little bit more. And that is the way the community sees the role of the judge. So in the state court system, and I'm sure you've all read this idea and seen it, but the idea that justice is blind gets at the idea that the judge should be almost naive. Some people would say objective. I think that the idea behind it is more about like the judge should really be a blank slate so that they make decisions that are just based on the information in front of them. I think that that's impossible. I think as human beings, and that's what judges are, We are not computers. We can't make our decisions based on formulas. And so, we bring with us our biases, we bring with us our values, we bring with us our experiences. In the state court system, my role as a judge in the trial court and certainly on the Supreme Court, the expectation is that I check those things at the door. And I try to look at the law as independent of values, as independent of human experience in some respects. And I think that is directly in contrast with what tribal court judges do, which is, as I said, to really understand not just the person in front of them, but who they are to the community. There is always an expectation when you're working with someone who might be going away to jail or prison for a period of time, that they will always come back and be a part of the community. So as a tribal court judge, I was always thinking about, how does this person reintegrate? How do we support them so that they're not causing problems in the community, but become an active, positive participant in the community? In our state court systems, we're much less thinking about that question, and we're much more limited in terms of what we can do to address the problems that bring people into our communities. I think that's changing. I think there's a lot more interest at every level of our legal system to make our legal system more responsive to the people who are there and to the public that the people who are in the court system might be impacting. But I think that transition is very slow, and I think it's very complicated, and it's a much larger system. So that's a place where I see some of the bigger differences.
And now we have some questions about your work today. First up is Neha.
Hi, my name is Neha Taneja, and I'm a senior at Lake Washington High School. I learned that when you were a court judge in Whatcom County, you presided over the therapeutic drug court. From your experience, do you feel that since you were appointed in 2019, progress has been made in cases with those who suffer from substance abuse issues?
Say yes and no. Substance abuse is a huge problem in our communities across the state. I'm sure you all have had some contact with that in one way or another, or experience reading about it. And you know that the consequences of addiction on all of us in the state are significant, whether that impacts us directly in our individual families or whether it's a larger societal issue. It's a big problem. And I frankly think that what I've seen over the last few years, and I think this is something that people who work directly in addiction all the time would agree with, is a pretty significant increase in people who are using in ways that harm them. And that's sort of one end of the spectrum, as well as people that are using in an addictive way that results in them potentially losing everything and ending up with, no family that supports them, no way to support themselves, sometimes becoming unhoused. All of those things are things that are a wider societal issue that I think are increasing for a whole host of reasons. One of those reasons, I think, is that we're talking about it more and acknowledging it, and I hope bringing less of a shaming approach to the people who are struggling with addiction. And I think that the legal system has to adapt to the reality that there are more people struggling with those issues. We don't have a great structure set up. If today everyone who is dealing with addiction said, I want to go to treatment tomorrow, we do not have the resources to support everyone who wants to go there and get help. So that's a place where I think we have a long way to go before we're in a position of really tackling that issue at its base, at its core. And the real core question is, what's happening? Why is that something that's becoming a bigger issue? What are the drivers of that? That's something I hope your generation takes up, because I think my generation has a pretty punitive approach to that question. So I think that the legal system is definitely adapting and recognizing that we have better success if we take a therapeutic approach as a legal system. And ultimately, over the long run, it's probably economically better if we are approaching things from a therapeutic perspective as opposed to sending people to prison over and over and over again. And so I think that there's progress, but I think it's incremental. And I think that there are lots of people my age who were really raised with the idea that we are individually solely responsible for our choices. And so if I develop a problem with addiction, it is my problem to solve. And I think that it really leaves out the important aspects of how that one person then might have an impact on the community as a whole. And I have seen over the last few years a shift in an approach and people really wanting, judges really wanting more resources so that we can tackle the bigger questions in a therapeutic manner and get people to that place where the person I talked about earlier is. She's an outlier, unfortunately. We have great success in drug courts, but there aren't very many spots for people to get into those programs. And so what you see more of is people coming into the system, spending 9 months in jail, and then they're back. And so that cycle is something we need to break, but it really takes the public saying, that's our goal. We want to do that. We want to put resources towards that. We want tax dollars to go towards that. We want programs in the legal system to go to that. We can't do it on our own as a legal system. And so I'm really glad to hear of all of your interest in this, because it really is going to come down to you saying we need to do that and bringing, more and more people towards that, what I hope can be a common goal of overall community health. And this is one aspect of it.
Jaden has a question about the Indian Child Welfare Act.
My question is, why has ICWA been a big focus for you?
The Indian Child Welfare Act has been a focus for me really my entire career. The basic idea of the Indian Child Welfare Act is a response by tribes who went to Congress and said, over the last 100 years, there has been a federal and state policy to remove Native children from their parents, most of the time without the permission of the parents, and put them into non-Native adoptive homes, put them into boarding schools, with the goal of those boarding schools being this is a direct quote from one of the founder of the boarding schools that were hundreds, thousands of Native children were sent to, where the goal of that boarding school was to kill the Indian and save the man. The idea being, let's take everything away from them that makes them Native, their language, their hair, their religion, the way that they were raised and educated in their home communities, and train them to be soldiers, train them to be maids, train them to work in kitchens. My great-grandparents were sent to those boarding schools. Though there is a long history in my own family of the impact of boarding schools. And so it's something that I care very deeply about from a personal perspective, because I can see in my family the impact institutional boarding schools had on my family. When I first became a judge, I was very young. I was in my late 20s. It's pretty unusual to have someone that age with in a position that has that much authority. I started doing child welfare cases in the tribal courts and started seeing that we had issues in families that were affecting children that were really different from the child welfare cases that I had learned about when I was in law school. And most of those issues came from that generational trauma that I just described a little piece of. So I became very passionate about ensuring that judges in the state court systems understood the federal Indian Child Welfare Act. And the basis of that act says that children are the future, Native children are the future of their Native communities. and they benefit from being raised in their communities, learning their languages, and they are not just the quote unquote property of their parents, but they are also a tribal resource. So anytime a Native children is removed or about to be removed from the care of their parents or their family of origin in the state court system, the trial judge is required by the Federal Indian Child Welfare Act to notify the tribe, and the tribe can come into the court and object and say a number of things. They can say, this is where we think the child should stay if they can't be safely kept at home. And there's a series of approaches that the law requires that is intended to preserve that child's connection to their home community. If that is really followed, in my opinion, and not just mine, but many judges, many social workers, people who do this, it really is the gold standard for how we work with families in crisis. Most children, not all, and those of you who are, all of you are high school students and teenagers, and sometimes I'm sure you're just completely frustrated with your parents and you just think, these are not my real parents and I just want to be somewhere else. But most of you, and most of the kids that I have worked with, in your heart of hearts, you want to be with the family you were born into. And you can't always be there. And that's true for families who are in crisis. But my experience has been, and I've worked with hundreds of families and hundreds of children whose families were in very serious crisis that affected the safety of those kids, that if it was possible to keep them connected to their parents or to keep them with their parents, and that they always did better. And that's always what they wanted. And even when they couldn't go home for some reason, a parent had a drug addiction that put their health, the child's health and safety at risk, for example. And it was just not something that they could get a handle on despite the support and the help of the social workers and the courts and so forth. Even the child might agree, okay, I can't go home, but I still want to have contact with my parent and I want to live with my aunt. The Indian Child Welfare Act gives some voice to the children in those circumstances. It gives voice to the tribal community of that child, and it also gives resources. And so that's something that is, I think, the way we should always do child welfare. It was not the way I was taught about child welfare when I was in school. So once I learned how this can be successful, it became very passionate, not just about ensuring that people followed the law, but also that they took the principles behind the law into any kind of child welfare case. Because in general, people do better if they are supported and if the goal is to keep their family together. Like I said, it can't always happen for a variety of reasons. And when it can't, we try to find as good a solution as we can. So it's something I care very deeply about. I'm passionate about the health and safety and welfare of children. And I'm very passionate about the continuing survival of my tribe and the tribes of all Native people. So those have been foundational drivers for me throughout my career.
And now thinking about mental health issues, this next one is from Ella.
Hi, my name's Ellie Ansari. I'm a senior at Lake Washington High School. So, as your stance is expressed while interviewed by NAMI, the National Association of Mental Illness, what legislation do you feel must be enacted and enforced to best support members of marginalized communities facing mental health concerns and a lack of resources?
The huge issue is the impact of people's mental health on the choices they make day to day. And so very often, if you have people who have mental health challenges, mental illnesses that don't have to resources, medication, therapy, support groups, all of those things cost money. And we definitely don't have enough resources to ensure that everyone who needs that help gets it. So what often happens is those folks end up in courtrooms across the state, across the country, because they have an uncontrolled mental illness that is causing them to to get into all kinds of trouble and create all kinds of trouble. I think that the best thing that we can do, and I do think that this is an aspect of legislation that we could have, is to widen the ability for people to have access to care that is tailored to their needs. So I think if we were able to do that, and really get people out of the cycle of getting into trouble, going into jail, getting out, and then coming back in. And in my experience in state trial courts, I saw that all the time. I would see someone who was clearly having a psychotic episode, who had committed a crime. We would get them the help they needed in terms of mostly medication when they were in jail. Then they would leave jail because they served their time for whatever the crime was. Then they didn't have access to the medication anymore. And they'd be back in I think the fastest turnaround I had was 16 hours. So they walked out of the jail and then were back in custody within a day. Because they didn't have anywhere to go. So they left unhoused, no supportive housing, didn't have any family that could help them. They ended up back in front of me. But that's a very common story. It's a huge frustration for judges because we have such limited resources. It's a bigger issue though than just the legal system. And I'm sure you see it when you walk around your communities. So I think that in terms of what we could do legislatively, the more we can expand access to services that people need, I think the better off we are. And sometimes people hear me say that, and they hear that as a sort of a radical idea. But at its core, it's really saying if someone needs help, we should get them that help. And that's really what I think we could do that would make the biggest change. Getting people help is expensive. Getting people help when they don't want that help is very difficult. And we don't really have a societal structure to do that tomorrow. But I think we could build towards it. And I think there is a growing movement towards recognizing that. There are mental health issues in my own family. I personally have struggled with depression and anxiety. I'm in a very privileged position to have access to all the healthcare I need. And that has been a tremendous part of my success, right? Just to know if I'm struggling, I can go to a doctor or I can make an appointment with a therapist. And the reason I have that is because I am a professional person with access to those things. But that it shouldn't be structured in such a way that the only way you have that kind of access is if you're someone like me. Everyone should have access to the things that they need in order to be functional in our community. So that's something I hope will shift over the course of the rest of my life and the rest of yours.
You've shared so many inspiring stories, Justice. Thank you so much. This next question from Dennis is about furthering justice.
Good afternoon, Justice Montoya-Lewis. My name is Dennis Egan, and I'm an 8th grade student at Open Window School in Bellevue, Washington. I learned during my research that you worked as a tribal justice on behalf of multiple tribes in Washington state. How has this informed your perspective on diversity in the state Supreme Court? What's an example of a decision that reflects this background? Thank you.
That's a wonderful question. And something I think about a lot. You've probably run across the idea in the course of your studies of this concept of what it means to have a, quote, seat at the table. Well, what does it mean? For example, if you're talking about child welfare and you have someone who grew up in the foster care system sitting at that table in the room with the people who make decisions about what the foster care system would look like. I can tell you, because I've seen that exact thing happen, that if you have people who have life experiences with whatever you're talking about, also part of the discussion about how to solve those things, the conversation is completely different. And I knew that coming into this new position on the Supreme Court where there'd never been a Native person at that table. And it is literally a table that we all 9 Supreme Court justices sit around to discuss things. I think there are multiple examples I could give you about how I think my presence and the presence of others, because we have many firsts in our court. We have the first openly LGBTQ person on our court. We have the first Latino person on our court. We have the first Asian American on our court. We have the first Black, lesbian, disabled justice on the court. We have a lot of firsts in that room. The conversation in that room is very different from the conversations I've had in similar kinds of rooms that don't have that kind of diversity, because we have wildly different experiences from each other. So very briefly, a couple of years ago, we had an attorney come to us and say, there is an old case called State versus Towasnoot, and you can go on to the Washington State Supreme Court webpage and find this. And Mr. Towasnoot, who was a Native person, member of the Yakima tribe in the early 1900s, was convicted of fishing outside of treaty boundaries and had a criminal record. His descendant said that was a violation of our treaty rights as Yakima people, and it's wrong. And there was a decision, a printed written decision you can read, that described Native people, and unfortunately there's lots of examples of this, but this particular case was written by our Washington State Supreme Court in like around 1910, maybe a little bit earlier, 1907, that described Native people as savages, as people who were unintelligent. It is a devastating case. And I went to law school and read many, many cases that described me and my ancestors in that kind of language. And so we had his descendants come to the court through an attorney and say, we would like you to reverse his conviction and vacate it, and do so in writing. Essentially, they were saying, please right this historical wrong. When we very first started having the conversation around the table about that, I was able to share with the court what it felt like to be a law student reading a case in my first year of law school that described me as a savage, that described me as unintelligent, primitive. You can think of all of the words that are attributed to Indigenous peoples, and what it was like to have that experience, and what it was like as a justice to read that case that was now in front of us as a Supreme Court justice. I think everyone in the room would agree that hearing that personal experience made them look at the request more seriously. It humanized that request. And so ultimately I was asked by the court to draft the decision that said, yes, we are going to vacate this conviction, and this is why. But not only did they ask me to do that, and this was not something I sought, but it was something that was asked of me, they asked me to read it and record it over Zoom. This was during COVID, so that it could be a part of the archives of the court that anyone could go and see. And it's related to our Supreme Court's commitment that we do whatever we can to make our legal system more equitable, but also to right our historical wrongs, and there are many. And since then, that is something that if we have a case that comes up, that brings up a case where there is, awful racist language in the case, we no longer ignore it. Sometimes it's just in a footnote, but we say, we see this, and we reject it. So that is something that I will not say is just because of me, but it is a result of having diverse voices in the room with the kind of power that we have. And the kind of power that we have is awesome and tremendous and weighs heavily on each of us. And we take our responsibility to justice, which is a word that I think is an action, not just a noun, that we do that every day.
And for a slight change of subject, Caitlin has a question about something that is on everyone's minds lately.
Hi, I'm Caitlin Henches, and I'm a senior at Lake Washington High School. My question is do you solely believe in the letter of the law or the interpretation of the law? And with that, do you think that using artificial intelligence will help justices in the future make more educated and better decisions?
I have an 18-year-old son who is very involved with coding and AI, and I've learned a lot from him as he's developed that interest. I think we have a long way to go before we can really rely on AI to give us research that we can be sure is correct. But I think the biggest problem, and I presume that people who know more about this than I do, and I would include my son in that, I think we have a long way to go before that technology is able to do analysis that really takes into account individual needs, as well as understanding the subtleties of the human experience. So far, I haven't really seen AI that's really capable of doing that. It's very much responsive to what you put into it. I do think that the law is important, and maybe that's a silly thing for a justice to say, but I do think that what we do as a society, what we say is right or wrong, is reflected in our laws, and I think that's very important. That said, I don't ever sit down to do my work without remembering that our history as a legal system is a very dark history. It is a history that is imbued with the idea that we want to subjugate some and we want to raise up others. And really the idea that we should have a truly equitable system is a new one. So a lot of times people say to me, what do you think's gone wrong in the legal system that we have so many, such a high percentage of people of color in our prisons? And there are numbers of examples I could give you, and I'm sure that you know many of them. And this is something that I think has really come out of the Black Lives Matter movement, where there's been a lot of discussion about what's gone wrong here. And I am willing and say this openly, publicly, and as does my Chief Justice Steve Gonzalez, that the system is working as it was designed. It was not designed with people like me at mind to be at the top. It was not designed for people like Chief Justice Gonzalez to be the Chief Justice. So if the system is working as it is designed to do, the question then is, can we change that system so that it is fair and equitable? Or do we have to start at the beginning? I don't have the answer to that, but I do think the question really matters. And I think that question is something that the human experience has to answer. And I don't think that AI by itself can do that yet. I'm convinced it will get there. But at this point, I think that there's a long way to go to really develop that kind of historical understanding and what that actually means in terms of people's lives. And quite frankly, people that have sat in my seat at the table that I sit in have done a lot of harm. And so I think that takes people to fix, not computers.
Now, Justice, we'd like to turn our attention to the future with these last two questions. Vita's up first with a question about your ideas about the purpose of the law.
Hi, my name is Nevada Nair. I'm an 8th grader at Open Window School in Bellevue, Washington. And my question is, in your experience, how can the legal system better address issues of social justice and ensure equal access to justice for all? Thank you.
So I will just kind of build a little bit on what I started talking about in response to the prior question, to say that I think the biggest thing we can do as a legal profession, as lawyers, is to expand who gets to be lawyers. So that's related to some of the work I talked about before, related to how we license people to be lawyers. But it starts much, much earlier than that. right? It starts at your age. It starts when you're younger than where you are now, maybe with some of your younger siblings or cousins. Very early on, we need to teach young people in all of our socioeconomic classes. We need to teach people from all diverse communities, languages, etc., that the law can be a profession where people really can make change. And that in order to do that in a way that is more fair, more equitable, all of the things that you've all been asking me about, we have to have different voices, different approaches, different life experiences. And those are things that change the way the law gets taught. So people who teach the law need to be from diverse communities. Up until the last 10 years or so, the vast majority of law professors came from 3 law schools. Probably guess what they are: Harvard, Yale, University of Pennsylvania, University of Michigan, maybe 10 law schools. Most law professors came from a very small number of law schools. So what does that mean? It means that they teach people who want to be lawyers that there is one way to approach the law. That can't be true. There's just too much diversity of human experience for us to really commit to that. And as a legal system, we have totally committed to that. So that has to change. And I think that really starts really early in people dreaming that maybe I could be a lawyer. I think this is true of all professions, that, we're not all raised with the idea that we could be a lawyer, or we could be a doctor, or we could be an artist. But it's really important to support whatever those dreams are. And I hope that there are people in your generation, as I said, I have kids in about your age range, and the way they talk about gender, the way they talk about racism, the way they talk about any of the issues we've talked about today is totally different from the way I was raised to think about those things. And so I want that in our legal system, because I know that if we get more voices into a field like the law, where we are problem solvers primarily, that we will have diverse ways to solve problems, and that means we'll have better approaches. Because I'm looking at all of your faces, and I know that if I just take one approach to solve whatever problem you might bring to me, I'm going to fail. But if I take an interest in you individually and what you bring to the problem, and I think about what I can bring to the problem, together we're better. So I think that is an approach we need in our legal system. And I want to just say, because it connects to the very first couple of questions you asked me, that is really in tension with the idea that justice is blind, that judges bring nothing with them except a narrow view of what the words on the page say. So in some respects, what I'm sharing with you about my approach is quite a radical one. And I've had people say that that's true. Maybe it is. But I think it's fairly simple to bring the idea that if you have more minds with more experiences to solve a problem, you get a better outcome. And that's really all I'm saying. And I think that that's really important. And I hope that that's the future.
All right, the last student joining us is Vienna.
Hi, my name is Vienna, and I'm a senior at Lake Washington High School. My question to you is, reflecting on your experiences in the tribal courts to the Washington Supreme Court, what advice would you give to aspiring judges, especially those interested in working with diverse legal systems?
The biggest advice I would give is to remember that when you put on the robe, I'm sure you've all seen that on TV or whatever, when you put that robe on, that you also remember that you are just a person like everybody else. But for a couple of choices I made as a teenager, I ended up on the side of the law that allowed me to wear that robe. And we wear that robe so that we all kind of look the same. That's the idea. Justice is blind, right? And we're all, doesn't matter who we are underneath. I don't, as you have heard, because I've said it 17 times so far, I don't believe that. I think that it's a better system the more we bring who we are to our decisions, and also that we remain humble and have some humility about the fact that we get to put on those robes. It's not just because we're really smart and, it's all merit-based. It is not those things. It's because we had, maybe it's arrogance, maybe it's vision, whatever it is. We had the interest, desire to be judges. We were able to conceptualize of ourselves as judges. And I will just say, other people had this dream for me. I never intended to be a judge in the first place. Certainly never imagined being on any Supreme Court anywhere. Other people had dreamed those things for me and helped me to see it was possible. So I try to remember that, that it could very easily have ended up the other way, that I was on the other side of the bench. I had access to some privileges that others didn't have. I had access to education that others didn't have. I made choices that were different from the people who are in front of me in the court. But those aren't all things that rely just on me as an individual. And so when I work with people who are becoming judges, I try to get them to remember that we all kind of start in the same place, in the sense that, we didn't know anything about the law. And somehow we learned about it. Somehow we dreamed this dream to become judges, but we got there through the support of other people, the privileges that we had access to in terms of education and the ability to fund that education. And that doesn't make us better than the people who we are, I hope, trying to help as judges. I don't necessarily get every new judge to believe that. But I think if we even get people to start to wonder a little bit about, could my life have been different? Are there people in my family or my community that are on the other side of that bench because they didn't have access to the same schools I had access to? These are the questions that I hope new judges ask themselves. And I hope that judges who've been sitting on the bench for 20 years continue to ask themselves. Because it's very easy. I'll just wrap up with this, that when I became a judge, and definitely when I became a justice, all of a sudden I got a lot funnier. People laughed at every joke I told, and I crack a lot of jokes. It's part of my culture. It's an aspect of who I am, that a lot of Native people communicate through humor. It's a big part of the way that I communicate. But I'm not funny all the time. But all of a sudden, I had this title in front of my name that you see on the screen, and I got a lot funnier. And so I started thinking, I'm hilarious. I'm so funny. I am very good at telling jokes. Nothing changed. What happened was that people were like, she's a justice, so we're going to do what we can to be supportive and respectful. It doesn't come from a bad place, right? But I didn't suddenly get funnier 4 years ago. I'm the same person. And so I think I'm a little funny, and I hope people laugh at my jokes. But I have to remember that it's very easy to get used to people opening doors for you and people calling you your honor and standing when you walk into a room. It's very easy to slip into like, this is about me and I deserve this. So I hope the new judges remember, it's about respecting the role, and it is important that we respect judges. But it is equally as important for the judges themselves to remember that they are also just people. So that's my what I try to remind people who want to be judges, who are become new judges, and it's something that's very important to me personally.
All right, thanks again for inspiring our students today and for joining us, Justice. And thank you, students, for all your great questions. That does it for this episode of Connects, and we'll see you next time.
Thank you.
Thank you, Justice.